The National Prosecuting Authority says it hasn't made a U-turn in the second docket in the Senzo Meyiwa murder trial. It's issued a statement to clarify media reports suggesting this. The docket has been transferred to the Director of Public Prosecutions in Pretoria from Johannesburg. The NPA maintains the decision contained in the docket will be considered after the conclusion of the current trial. The NPA also saying that the docket in question relates to the first case, which details what transpired on the day that Meyiwa was killed. It further adds that the second docket was opened in 2019 by 2 police officers who were part of the initial investigating team. Well, joining us for more on the story, particularly the legal implications of this, we're joined by legal analyst Modidima Mannya. Good evening to you, and thank you so much for your time. Help us make sense of this. The NPA saying they're going to make a decision on the second docket once this trial has been completed. These are 2 completely different variations of what could have unfolded on the day that Senzo Meyiwa was killed. Why is it so difficult to decide which one to go with, especially if the state is as confident in its case as it says it is?
Yes, I mean, Kathy, I'm as confused as you are, and probably the statement issued by the NPA has just created even more confusion. You know, my understanding was that there were 2 dockets. One had been investigated and no decision had been taken to prosecute in that docket or not to prosecute. So in a way, the NPA always left the door open that they could revisit that docket and make a decision whether to prosecute or not to prosecute. But we must bear in mind that there are 5 accused before a court now charged with the murder of Senzo. And one of the charges involved is the assault on 2 people who were in the house. I think it's Ms. Kumalo and her mother. Now, quite significant is that you would have to bring it either of the 2 to at least give evidence about the assault, and obviously probably to give evidence about the murder itself, because the assault would have occurred in the context of the murder. Now the NPA is coming back, it's saying, look, in their statement at least, we're waiting to see whether the credibility of any of the people in the house is not going to be challenged to make a decision. That means, firstly, that they intend to call some of the people or the people who were in the house to give evidence. But secondly, it seems like they are double parked now, because if there is at least a prima facie basis to believe that any of the people in the house was involved, those people should be appearing in court with the other 5 accused.
So, in as far as the current trial is concerned, I mean, can the legal representatives of these suspects make a concrete argument for this case to be thrown out of court simply over the issue of what the NPA is saying about the second docket?
Not at all. I mean, the charges are before court. What the NPA must do is to lead evidence. I think the untidiness in this whole matter is when you have a situation where people probably, and I don't know whether the second docket, in the light of this statement, makes a suggestion that the people in the house were involved in the murder, or whether it is still a question of the opinion of the investigating officer, probably out of frustration, because I suppose they would have, having interviewed whoever was in the house, maybe they formed a view that they are either not been told the whole story, or that the people are covering up themselves and they were involved. But you must remember that these 5 accused who are appearing in court, 2 of them, I think, are said to have made confessions. So it does not follow that they will not be convicted. I think the story that Advocate Gerinel has raised about a mastermind, I mean, comes back and it probably haunt us until either this trial is complete or the second docket is also activated, if it is ever going to be activated.
Do you think it's a case of having a plan B for the state if this current course of action doesn't go the way that they would want it?
Look, I wouldn't know what kind of plan B that would be. Remember, the people who are coming to give evidence, who were in the house, have a right not to self-incriminate. So I don't think anybody hopes that they will incriminate themselves and therefore build up a case. I must say that I think it should be very difficult if any of the people in the house were to say, yes, somebody in the house was part of the murder or committed the murder. It will be possible and probably easier to prosecute. But I suppose if all the people, and that seems to be what is the current state, they have said, all of them, it seems like that there was an intruder and there were people who shot, who were from outside. Now, how do you then say they are lying if you don't have anything to contradict what they are saying? And I think that's the difficulty.
All right. Modidima Mannya is a legal analyst. Thanks for your time tonight.